Hello again, it's Eric Kirkpatrick. I wanted to talk to you today about what to do if your workers' compensation case is denied. This happens more often than not, actually. It's something that occurs quite frequently. I would say 80% of the cases at some point are denied for one reason or another. So today what I want to talk to you about is what to do if you're handling your case on your own and all of a sudden the insurance company says, boom, they're not paying any more benefits, we're not paying any more medical care, and we're now disputing your case. Okay? First of all, let's talk about why your case might be accepted and then all of a sudden denied. Okay? The first thing is, one, maybe they find out that you didn't give your employer notice of the accident. You have 45 days from the date of your accident to give your employer notice, but try not to wait that long. If you know you've been injured, report it as soon as you can. The longer you go, even with an injury that might be obvious, the longer you go without telling the employer that you had an accident, the more likely your case will be disputed. Memories fade, supervisors change, people just somehow don't remember that a worker told them about the accident, especially if you don't mention it for 45 days. The next thing is, maybe the insurance company has decided that you didn't have an accident at work. An accident at work doesn't just mean you weren't hurt there. It means that they're claiming you didn't have an accident that arose out of and in the course of your employment. A couple of examples of these would be, if I am at my office, I'm working, and I bend over to tie my shoe, and somehow all of a sudden I have back pain. It ends up to be a herniated disc, something like that. That isn't something that arose out of and in the scope of my employment because I wasn't doing anything in the furtherance of my work. I wasn't doing anything associated with my job at Kirkpatrick Law Offices. However, to take that another step further and to explain my example a little bit more, part of my job sometimes is carrying these files back and forth. Some of them are large. If I bend over and pick up a file that weighs 45 pounds and carry it across the office and all of a sudden I have back pain, I am then doing something associated with my work. A lot of times the issue of accident arises if a person has an accident in a parking lot, or they fall walking across the floor at the office, just tripping over their own feet, or they're climbing stairs with nothing in their hands and they trip. Sometimes the insurance company will dispute those cases. The next thing that you have to keep your case from being denied is you have to prove that there is a causal relationship between your condition that you have, let's say it's a torn cartilage in your knee, and the accident that you suffered at work. Many times the insurance companies will be fine with paying somebody for a knee strain and going to the doctor to get a few x-rays, but the second that it turns out that it's something more, such as an MRI is needed that's going to cost them money, or surgery is needed that's going to cost the insurance company even more money, they will then try to put a stop to your claim, basically, and send you to another doctor who says that you don't need surgery, you don't need the MRI, you don't need any additional treatment, you're fine, and the accident that you had at work has nothing to do with the problem you've got in your knee. It's all related, for example, to you being a high school football player 35 years ago. They actually come up with that sort of thing. Now, if your case is denied, really, quite honestly, you probably don't have much choice at that point but to hire a lawyer who knows what they're doing to try to straighten out these issues. Because once you hire a lawyer, he or she files the claim, and many times these cases have to go to arbitration, where an arbitrator decides whether what happened to you constituted an accident at work. And also, to prove causation, sometimes you need a lawyer who takes a deposition of your treating doctor so he can testify to the things that he needs to testify to, that, you know, the specifics of, for example, how you climbing off the piece of equipment and landing wrong on your foot twisted your knee and caused a meniscus tear. You'll need those sorts of things to get your case moved forward and in order to win it. The Workers' Compensation Act will give you all sorts of rights. It will tell you everything that you're entitled to, and Illinois is probably one of the most liberal states in our area. You want to avoid ever getting hurt in Kentucky or Indiana and even Missouri. Their laws are not as favorable to the petitioner. So that's your remedy. I think is probably you need to hire a lawyer if your case is denied on any of those factors. Those are the three big ones. The two big ones of the three where I see most disputes come about is the causation aspect and accident. Causation usually comes, you'll hear from the insurance company and you'll hear their dispute on causation when it comes time for some sort of surgery. They'll claim it's related to arthritis even though you never had any problems before. And all they need is a medical opinion that makes any sense at all, and they can dispute your case and make you prove it to the arbitrator. They don't have to accept your claim. So now what I want to talk about is, if you're handling your own case, things you can do to avoid your case being denied. Okay, first of all, let's go back through the same things we talked about. Report your accident immediately. Don't have an accident on a Friday and think, well, I'll report it Monday, because that is a red flag to the insurance company and your employer that you probably weren't hurt at work, because Friday should have been the day you reported it. They'll assume, especially in the summertime, that you've been out on a boat somewhere. They like to throw that out, or you were doing some sort of summer activity. In the wintertime, especially in the weather, they'll try to claim, well, you might have been out shoveling snow, that sort of thing. Report your accident immediately. Also, report it to a supervisor. Telling your coworker, oh, I hurt my back while we were lifting this heavy box or crate, doesn't suffice for notice. You have to tell an employer. Tell your employer, your supervisor, even if you think it's not going to be a big deal. It doesn't have to be on a written form, but you make sure that you tell a supervisor. One of the things that you can do that a lot of people don't understand what they're doing. They like to believe that the insurance company and things has their best interest at heart. But let me explain something to you before I get into this one. Your employer may be the best employer in the world. You may get along with them just fine. They may think you're the greatest employee that ever lived. However, 99 out of 100 times when you are injured, your case goes to an insurance company to defend the claim, because it's the insurance company that's out there to have to pay your medical bills and your time off work and then the permanency award. You are nothing to that insurance company other than a complete number, and they are going to try to get away with as little as possible. Their interest is completely contrary to yours. I say this even though people think that their employer is great. Sometimes the insurance company won't listen to the employer at all. So some of the things that you can do are, one, sometimes as soon as people are injured and trying to handle the case on their own, the insurance company comes in and says, here, sign this authorization. It just lets us get your records. You have to read that authorization closely, because sometimes that authorization will also say, and you agree to let us write to your doctor to get reports. You agree to let us talk to your doctor outside your presence. You agree to let us call up your doctor and talk to him without you being there. You agree to let us send videos to your doctor, etc., etc. You absolutely do not want that to happen. Not at all. The reason being, you have the right to privacy between you and your doctor. The Workers' Compensation Act allows them to get the records and the records only. To use an example, I have a case right now where before I was ever involved, the client signed an authorization allowing the company, the insurance company, to talk to his doctor. Well, the insurance company decided to send the doctor a video of this man doing something that really didn't matter in the grand scheme of things, but they had the opportunity to doctor it up and make it look 10 times worse than it was. So then the doctor, without my client knowing, thought, well, if he can do that, then he can go back to work full duty. My client didn't know he was released full duty. Not at all. It all happened behind his back. Don't sign that authorization without limiting it to say, this does not permit ex parte communication, or in other words, this does not allow the insurance company or its agents to talk to my doctor outside of my presence, period. That's the rule, that's the law, there's nothing wrong with you doing that. Another thing that you need to make sure that you do is whenever you see a new doctor, you make sure that that doctor knows the history of your accident. Give the doctor a detailed history of exactly what happened to you. Don't assume that the insurance company gave him a history. Don't assume that he knows about your claim, because if you don't tell the doctor what happened, when it comes time to prove that there's a causal relationship that I referenced a moment ago, the doctor's not going to have a history in his note, and that will come back to haunt you. We then have to prove that you really did have this accident, because the arbitrator can get all flustered, and a big deal can be made out of the fact that you haven't reported to your doctor the accident. If you don't report the accident, then the doctor has a hard time testifying that an accident you had caused the condition that you have. The other reason the cases are disputed, as I said, is when the company decides they've had enough and they're not interested in paying for surgery, and they send you to a doctor of their own choosing. What I tell people with these examining doctors is, one, be yourself. Don't over-complain. Don't give the doctor any reason to suspect that you're lying or exaggerating. Answer the doctor's questions. Don't tell him any more than he asks. And again, make sure that you give a detailed history. I tell folks, keep track of the time that you spend with that examining doctor, because oftentimes the doctors will generate a 5-page report, and when I ask the client how often or how long they spent with the doctor, it might be 5 minutes. As you can see, a lot of the rest of the stuff in that note is just a summary of medical records based on what the doctor wanted to put down. So with all that said, in a nutshell, if your case has been denied, you likely do need to hire a lawyer, and make sure it's an experienced workers' compensation lawyer. This is a different animal. And hopefully, if you are trying to pursue the case on your own, I've given you some good advice on what you should do and what you shouldn't do. Thank you.